welcome to Constangy TV's Close-Up on Workplace Law, where we zoom in on recent developments of interest to employers, to their attorneys, and to their human resources professionals. I'm your host, Leigh Tyson, and I'm a partner in Constangy's Atlanta office. Just about every employment law has some sort of provision against retaliation. At the Equal Employment Opportunity Commission, actually the majority of the complaints that are now received are based on retaliation. But it's not just EEO or discrimination laws that have these anti-retaliation provisions. It's also the Occupational Safety and Health Act and the Fair Labor Standards Act and Sarbanes-Oxley and the National Labor Relations Act. And in addition to that, you also have a whole bunch of state statutes that also prevent any kind of retaliation. So here today to talk to us about that and help us understand retaliation and what we should and should not be doing is Kristine Sims. And Kristine is a partner and the office head in our Winston-Salem, North Carolina office. She represents and advises employers in all kinds of labor and employment law, and particularly with anti-discrimination statutes. And she also does a lot of work with affirmative action compliance as well. So she's a perfect person to be talking to us about retaliation, and we're excited to have her. Kristine, welcome.
Hi, Leigh, and thank you so much for having me. I'm glad to be here.
Now, retaliation is clearly a matter of great concern for employers, right?
It really is. The charges that have been filed with the EEOC over the past 5 years for many categories have decreased as the years have passed. However, retaliation charges have actually increased in the past 5 years.
And why do you think that is?
Partly because employees and their lawyers know that they can make those claims, and also because I think retaliation can come so naturally.
Okay, what do you mean by that, coming naturally?
Sure. So let's say that an employee makes an internal sexual harassment claim. And let's say she makes that complaint against you, Leigh. What's your reaction going to be?
I'm going to be really hurt. I'm going to be scared. I'm going to be worried about my job. I'm just really upset.
Yeah, absolutely. And you're probably going to be a little bit angry.
Oh, I'm definitely going to be a little bit angry. I'm going to be real angry.
And some extreme examples could include firing somebody, demoting them, cutting his or her pay, but certainly those subtle forms of retaliation we also see allegations of in charges and in lawsuits, such as work rules that are on the books but not actually enforced, and all of a sudden you start enforcing those rules. Or you might start micromanaging that employee where that's not your natural instinct to do so, or certainly not something that you do with that employee's coworkers or peers. Or worse, you could just not deal at all with that employee, not even in professional business dealings, and you're kind of excluding them. It's also not uncommon for the manager to be afraid to manage that employee at all.
Yeah, and it seems like, the employee might love that, but at the same time, is that some sort of weird reverse retaliation?
In a certain way, absolutely. You can argue that it is. And the real problem with failing to manage the employee is the employee isn't held accountable. The coworkers become jaded, and you've got morale issues, and they're angry. And they get and the manager winds up getting angrier and angrier with each passing day until there's an explosion, and sometimes over something extremely minor.
It's clearly very tough for employers to handle current employees who have filed internal complaints or filed a charge or a lawsuit against them. I guess in that sense, it's a good thing that most employees wait until after they've left or after they've been fired before they actually go ahead and file a charge or a lawsuit then.
That's true, but just because the employee is left doesn't mean an employer is out of the woods from a potential retaliation claim. They need to watch out for post-employment conduct that can also be seen as unlawful. For example, if you give an ex-employee a bad reference because he or she filed an OSHA complaint, that would certainly be considered retaliation. Or if you fight an ex-employee on unemployment benefits claims because he or she filed an EEOC charge, but your normal practice is not to fight unemployment benefits claims, certainly you could be liable for retaliation in that sense as well.
Really looking at all this, it's kind of a wonder we don't have double the number of retaliation claims that we already do.
I know, you're right. So luckily, most supervisors and managers know not to act on their personal feelings in the workplace.
We certainly hope that that is true. What kind of practical advice do you have for employers who are looking to limit their liability based on retaliation?
Sure. Well, first, you want to make sure that your supervisors and managers have a very good understanding of the concept of retaliation. I would always suggest including a segment on retaliation in any part of harassment training. And I recommend reviewing these retaliation concepts or anti-retaliation concepts in safety meetings and in other sessions where management training is taking place.
And really, that's consistent with the sort of training we do in the NLRA context, particularly when you have a union campaign. There tends to be a lot of high feelings and charges filed and bad things said about managers and supervisors just in the course of the campaign. And it's something we really have to kind of hammer home over and over again in that management training, is the avoiding liability here, it seems.
I would also make sure that if a company gets a charge or other legally protected activity, and especially if the employee is still working there, that there should be individualized guidance provided to that manager. On top of that, and this hint comes directly from the EEOC, and I think it's a really good idea, is that the company should provide individualized emotional support to the manager who's been named in a charge. We want to try to provide that manager with a safe place to vent. The one thing I would caution, though, for employers is to make sure that venting takes place with in-house counsel or with counsel present, so that it can be protected by the attorney-client privilege.
Yeah, that's a really good point. You definitely don't want to have to testify under oath about something you said when you're angry or having a weak moment. I know I certainly wouldn't.
No, definitely not. And fourth, if the manager wants to discipline or terminate the employee or take some other adverse employment action in regards to that employee, the manager should ask himself, how would I handle this situation if it were my favorite employee? They're thinking about it and they believe their superstar employee would have gotten a verbal warning or a written warning or a suspension or some other disciplinary action. Then the manager may want to go forward with that same disciplinary action.
Now, I'm using my listening ears. I noticed you said nay.
Sure, I'm not getting anything past you, am I, Leigh? No, you're right. That manager should always confer with HR first before issuing any disciplinary action, and go ahead and get the company's attorneys involved as well.
Makes sense. All right. Well, Kristine, this has been super helpful information. Thank you so much for being with us.
Thank you so much, Leigh. I enjoyed it.
And that's it for this edition of Close Up on Workplace Law. Thank you so much for joining us, and hope to see you again next time. Bye-bye.